May I be the lordship?
Yes.
Lordship, last night my elder brother expired, my lord. So my lord, item number 23, my lord.
23.
Maybe on, since it is a 14 matter, my lord, maybe on 6th day after tomorrow, my lord. I'm not in a position to conduct any case, my lord.
23.
Item number 23 orders, my lord.
Ah, this contempt matter
Yes, my lord. It's a old matter, my lord. So my lord, day after tomorrow, maybe.
been complied with, or who is for the other side?
Government's, my lord.
Hmm? Cannot be government, somebody must be from the government. Okay, on the prayer of Mr.
M.U. Ahmed.
M.U. Ahmed, Land Council for the petition, let this matter be listed after 2 weeks.
No, my lord, on 6th, my lord, day after tomorrow.
Why?
It's a old matter, my lord. So my lord,
6.
subject to your lordship convenience, my lord.
Hmm.
6th, my lord.
Lordship, in regards to item 17, with the consent of the other side, I'm saying the matter may be urgent today.
17.
Yes, Lordship.
By order. Who has mentioned this?
The petition was there.
Hmm? Who is for the petitioner?
Yeah.
Have you taken consent?
Lordship, yes, consent has been taken.
Okay. On the prayer of Mr.
A.K. Ghosh.
A.K. Ghosh, Land
Behalf of Mr.
Council.
K. Kumar for the-
Hmm?
On behalf of Mr. K. Kumar for the department.
Land Council appearing on behalf of Mr.
K. Kumar.
K.
Lordship,
K.
K.
Kor. A or K. Kor.
K.
K. Kor. Land standing cause PNRD. And the prayer not being objected to Land Council but petitioner. List this matter up to 2 weeks.
Lordship.
Lordship, I beg to mention item number 6.
Hmm.
In this case, Lordship, we will going to file today an IA.
What?
IA.
What IA?
IA for
2015 matter.
yes, Lordship, but IA for last occasion, Honorable Court may directed to file IA for implemented the finance as a party. So, Lordship, dear
Okay, on the prayer of MS?
D. Pathak on behalf of Mr. R. Day.
D.
D. Pathak, D for Delhi.
D.
D
Pathak
for
Land
Delhi.
Council appearing on Mr. Arde. Land Council for will list this matter after 2 weeks.
My lord, with consent of the responsible, my lord, item number 15, my lord, matter may pass over the field.
15.
Lordship.
Huh?
Yes, lordship. 1-5.
When do you want?
My lord, actually, my lord, similar nature of cases, my lord, the file, my lord, this honorable court, my lord, before the matter, my lord, the file, my lord, read appeal, my lord, which is still pending.
So what's after disposal of the writ appeal?
Lordship.
Mr.
Alan Ding,
Alan Dingya, Land Council for the petition, and Mr. D.N. Sahel, Senior Council for respondent 3 and 4. Assisted by Swain Shah. Have submitted that a similar matter is pending before the division bench. Therefore, praise for listing of the matter after disposal of the writ appeal. Is considered accordingly. List this matter after disposal of the writ appeal number.
my lord, read appeal number, my lord, which is, my lord, matter was fixed on, my lord, 26/8.
No, you give
But
them.
read appeal is not registered, my lord, number is not registered, my lord, but there was a, my lord, delay, my lord.
Then we'll make it.
I have a
The
trailing
matter be
number.
listed after 4 weeks. We'll make it 4 weeks.
Lordship. Oblige, lordship.
If needed, Lordship, I beg to mention item number 14, Lordship.
Hmm.
I inform to the other side, Lordship.
Hmm.
Lordship, matter may pass over for the day, Lordship.
Why?
Due to, Lordship, my senior is out of station, Lordship. And Lordship, the respondent is.
You are for
And Borua, Lordship.
petitioner.
No, Lordship, respondent, number 7 and 8, Lordship.
Who is for the petition?
I inform, Lordship, as I said.
You have informed.
Inform, Lordship.
Mr.
And Borua, Lordship.
Ken Boru, Land Council for Respondent 7-8. Praise for listing of the matter after 2 weeks on the ground that leading counsel has some personal difficulty today. List of fragile list after 3 weeks.
And
2 weeks.
4 weeks, kindly, Lordship.
Huh?
4 weeks, Lordship.
4 weeks. Huh?
I need some accommodation, Lordship. I need some accommodation, Lordship, with respect to item number 13, Lordship.
30.
Petitioner.
Contempt.
13 Lordship, 13.
30.
13 Lordship, 13.
Ah,
And for the petitioner Lordship, I've informed the other side. He's in.
Mr. On the prayer, Mr.
P. Sharma Lordship.
A. Sharma.
P. Sharma, Pranjal Sharma.
P. Sharma. For what?
For petitioner.
Learned counsel. Your name is not there.
Name.
13. Learned
Yes.
counsel for the petitioner. Come on, let this matter be listed after
Could be
3
following.
weeks.
Can it be Lordship, other side? Huh?
3 weeks.
Other side is the Sanjay Medhi is there. He goes to outside. Lordship. Can it be on 27th of August? Lordship?
Sanjay Medi.
No, no, it's,
SK Medhi.
SK Medhi, advocate.
Ah,
He
he's
used
from
to go
where?
outside Lordship. So
He's not from Gauhati.
no,
He's from Guwahati. Can it be fixed on?
he used to
27th
go outside, outline benches. Let's say.
So we'll make it 2 weeks, 3 weeks. 3 weeks.
May I please, I beg to mention item number 36, Malad. Only matter will be taken after 17, Malad. We have complete-
36. 36.
Yes, Malad. I
Why?
have taken consent from the other side also.
2016 matter.
Yes, Malad.
Huh?
I have taken consent, Malad.
Last Sanch.
Yes, Malad.
Mr.
K. Kolita.
K. Kolita, learned counsel. Why it should be adjourned?
Malad, my senior is not well.
Mr. K. Kolita, learned counsel for the learned counsel appeared for the petitioner submitted leading counsel Mr. I. Saikia.
Yes,
I.H. Saikia. I.H. Saikia, learned counsel, leading has some personal difficulty today. He is indisposed today, therefore, phrase for listing of the matter after 3 weeks, prayer is allowed. List after 3 weeks. However, it is the adjournment is granted as last such in view of the as the matter is pending since 2016.
yes.
May please your of the other side, I am mentioning item number 5 Lordship.
5. Item 5. 2014 matter, what remains here?
So engaged counsel is out of station.
2014 matter. This is dismissal from service. Dismissal from service. On the ground that Mr. M. Sharma.
It's Burga Lordship.
No, who is your senior?
It's Burago Lordship.
His name is not there. Item 5. His name is not there. It's senior lawyer. His name is not there. Item 5. It's Buraguay.
It's Burago Lordship.
His name is not there.
Actually, even my engaged counsel is also out of station also.
You are for?
Petitioner.
On the prayer of the learned counsel for the parties, let this matter be listed up to 2 weeks, please. Sir. It is made clear no further adjournment shall be granted on the next date as the matter is pending since 2014.
Nice.
Record their name.
Please, your lordship, item 38, had already filed a adjournment request yesterday.
Yes, on the prayer of Mr.
G. Kaushik for arts and so.
G. Kaushik,
For
learned counsel for
Arts and so. For the petition.
Arsenio, learned counsel for the petitioner. List this matter after 3 weeks.
In the month of September, date maybe.
3 weeks. They make it 4 weeks, not September.
Obliged.
May it please your lordship,
This is August, yeah. Yes.
may it please your lordship, with the consent of the other side, I beg to mention item number 11, lordship. I have been instructed by Mr. MP Sharma, the conducting counsel, that the file has been misplaced, lordship. This is a very old, after long.
On
it
the
is
prayer
not,
of Miss MS.
B. Mohanto, lordship.
B. Mohanta, learn because appearing on behalf of Mr. MP Sharma, learn counsel for the petitioner. List this matter
But I
after
am for the respondent number 2 and 3.
2 weeks, huh?
I am for the respondent number 2 and 3.
Mr. is that the learned senior counsel for respondent 2 and 3
Entry.
is present.
So, can a date be fixed?
After 3 weeks, you give the date. Yes, 3 weeks.
May it please your lordships. My lord, I beg to mention, with the consent of the other side, my lord, I beg to mention item number 25,
Much
30 and 31, contempt case, my lord. I would like to implement present incumbents, my lord.
25,
Each time may be allowed.
25,
25, 30 and 31.
that one, same order, huh? Say,
We have complied.
huh?
30, we have issued a speaking order long back.
Huh.
Ano yun?
30 na.
Ye gamen ako.
Then 25,
Rutan Kumar Das.
on the prayer of the MS K. Devi, learned counsel for the petitioner.
Ati di ko nalagay diya.
Is this
Implit ko
matter
ilaw
after
niki.
2 weeks?
Isadal pa ba lukin?
Same order in item 31.
Bo,
May I please, your lordship?
oblige.
Then item 30,
30, give. When it's same pair.
not complied. Same 30, 25, 30, 31, huh?
May I please, Your Lordship, with the consent of the other side, I beg to mention item number 37.
Hmm.
We have filed the
Yes, on the prayer of Mr.
K. Kolita.
K. Kolita, learned counsel for the petitioner, list this matter after 2 weeks.
My lord, with the consent of the other side, I beg to mention item number 42, my lord.
Hmm.
Last item of daily list.
Hmm.
My lord, the conducting counsel has some personal difficulty, my lord. Matter will be fixed after 2 weeks, my lord.
B. Pathak,
Yes, my lord.
on the ground that Mr. B. Pathak, learned conducting counsel has some personal difficulty today, Mr.
M. Sharma.
M. Sharma, learned counsel, preparing on their press for listing of the matter after 2 weeks.
Yes, my lord.
Praise the Lord, list after 2 weeks.
May I please, Your Lordship? I beg to mention item number 32 from the daily list. I have
30,
taken consent from the other side, Lord. 32, my lord.
32,
Yes, Lord. I have
Yes.
taken instruction from the client whether order has been complied or not, Lord. Long.
complied with.
No, my lord. Whether
You are instruction from us, from his client.
so after 4 weeks, Lord.
On the prayer of Mr.
D. Gogol, Lordship.
D. Gogoi, learned counsel for the list this matter after 4 weeks.
Lordship. Highly blessed.
May I please, your lordship?
Yes,
Lordship, I beg to mention item number 39 for an adjournment, lordship.
why?
Lordship, my senior could not come today due to flood in his area, lordship.
On the prayer of MS,
NM Longking,
NM,
Longking,
Longking,
on behalf of Mr. P.K. Deka, lordship.
learned counsel appearing on behalf of Mr. P.K. Dekar. On the ground that Mr. Deka has some personal difficulty today, therefore prays for listing of matter after 2 weeks, praise the Lord, list after 2 weeks. Hmm.
Obliged, lordship.
One to four. Top of the list.
For that, actually, my lord, what happened, my lord, in this matter, senior advocate Dipankar Nath, he is appearing, my lord. He is the today, my lord, not keeping well.
Hmm?
He is not keeping well today.
Hmm.
He told me, you go and appear. If possible, you do. If not possible, then take a time.
Okay,
So, lordship, I have not gone.
you are possible, now it's you are possible, we'll dispose it of what's there. Yes,
I don't know the facts also.
huh?
I am.
We'll
not-
hear, we'll,
Yes.
we'll the facts from
Let
him
Let
only.
him play. Let him
Huh,
play.
yes. Are you ready?
Yes, yes.
Ready for disposal?
Lordship, lordship.
Yes. Why, the 4 matters are similar?
Lordship.
They are constable.
Yes, no.
They
right
were
now-
appointed a constable,
Yes,
ultimately they were
Lordship.
promoted up to assistant sub-inspector,
Lordship is.
assistant sub-inspector.
Assistant Sub
You want that your juniors have been promoted to the post of sub-inspector?
Yes, lordship.
Although you have been retired,
Lordship.
you should be granted the same benefit.
Lordship.
What is the law?
And the.
What is the law?
Lordship. The similar situated lordship,
Huh,
the similar situated judgment of this honorable high court.
same facts.
Yes, squarely covered. Same case, same department, same, everything is same. Everything is same. Everything is same, lordship.
Why?
And for that, the copies with the file, lordship, the repetition number 657.
657. Consider.
Yes, Lordship. It is Honorable Justice Ranjan Gogoi was judge at that time. And the Honorable Justice Nayar was the advocate on that time also.
Who?
UP Nayar.
Who?
Lordship, if there is no judgment, is with me also, Lordship.
It's here, it's here.
It is there, no?
Hmm.
Yes. Lordship, kindly peruse para number 4, 6, and 7.
4, 6, and 7.
Yes, Lordship.
At the hearing of the three submission remain have been acknowledged by CUP London. Hmm. You are claiming from which post to which post?
Sub-inspector.
Hmm?
Sub-inspector.
Only.
And thereafter,
That cannot be.
thereafter up to continue till the retirement, Lordship, the benefits.
Hmm?
Till the retirement,
Cannot be like that. When did you retire?
Lordship,
The juniors have been promoted up to which rank?
sub-inspector.
That's all.
And up to that period, Lordship, during my tenure, Lordship.
Then now they are still working.
No, these juniors are.
Hmm.
Juniors are still working probably, Lordship.
Here there's a further promotion to the deputy
Juniors
superintendent. of
are
police.
probably juniors are also retired, Lordship.
So this case is to the next higher post.
Next higher post of
It's not exactly the same.
same
Same promotion.
same promotion.
Huh?
Yes,
Here, in this case, which has already been decided,
Lordship.
the
Same case.
juniors were promoted on the same date.
Same. Here this case, Lordship, here also same. The juniors have been promoted.
Then why, this is when? It was when? Decided when?
It is 2000, it is decided on 2005, Lordship.
Where you were? When did you file this writ petition?
It is decided on 2005,
Five.
Lordship. 25/5/2005.
But you have filed the writ petition in 2020,
20, Lordship.
after 15 years.
Lordship. But this order is still holding, Lordship.
No, these petitioners were working that point of time, at that point of time.
Lordship.
When you filed a writ petition after retirement.
No. During service period, I filed the writ petition.
When? When did you retire?
I retired on, Lordship, 31/3/21. I filed all the writ petition during my service period, Lordship. Even item number 4 is
Just
still
bef-
working.
Just before retirement.
But
1 year
item-
before
But
retirement.
item number 4 is still working, Lordship. Still he is in service.
Huh?
Item number 4,
Hmm.
still he is in service.
Ramakanta Pathar.
Oh, this fellow.
This is
Yeah,
Date of
5523.
your date of appointment is different.
Different.
Promotion is also different.
No, this three, item number 1, 2, 3 is same, Lordship. But item
Date of
number,
appointment,
yes,
initial appointment.
Lordship, almost same.
What do you mean by almost or same?
Lordship,
Must be-
I'm giving. Item number, item number 55. Item number 2, WBC 5520, Lordship.
You go, why, really, item number 1?
Item number 1, Lordship, item number 1 is, item number was 25/4/1984. Date of appointment, Lordship.
5331, Gopesh.
Yes, Gopesh Chandra Deka, and retired on 31/3/2021.
Appointed on?
Appointed on, Lordship, 25/4/1984
Yes, constable.
as a constable.
Then promoted
Then promoted to ASI, Lordship.
on
Then promoted to ASI, Lordship, 24/09/1998.
thereafter you have retired.
Thereafter, 2021, I retired.
When these juniors were promoted,
Juniors are promoted, Lordship.
you retired on?
Juniors are also
Retired on?
myself
Retired on.
retired on 31/3/2021.
31st?
3/2021.
Juniors?
Juniors, my lord, date of appointment 3/5/1984.
Their party here,
Yes,
who is appearing for this? Notice has been served.
lordship.
Junior is 6 and 7.
Lordship, 6 and 7, lordship will find page number 10, lordship. Page number 10 in the table, it is stated, lordship. Page number 10.
What is the reason why you have not been promoted?
Lordship.
What is the reason? What could be the reason?
Reason is only one thing, lordship. The departmental grade 1 examination, they have not
Clear.
yes, they have not clear, not appeared
Then,
at that moment.
ah,
And for this reason only, juniors are on that time, juniors already completed grade 1. That is why they have promoted to junior.
so what recruitment rule says?
My lord, with due respect, lordship, there is no rules at all in this organization. All are draft rule. Supreme Court says draft rule is not acceptable.
When no, there is no rule is
No,
not
there
fi-
is,
rule,
there-
if rule is not finalized, draft rule can always be
But
Acted upon.
there is not clearly mentioned.
where is the draft rule?
Lordship,
Where is the draft rule?
draft rule is, lordship, lots of draft rule is there, 2005, 2018, 2000, 2020. Now, which will they will accept?
No. Just before the draft rule, before the promotion, 2020. Hmm?
2020 draft rule is not with me, lordship. In 2005 draft rule, it is I mentioned in my petition, lordship. Lordship will find page number 6. But the judgment which I placed before you, lordship, in that judgment, it is stated that
There was no controversy. They have not filed anything in that case.
but the court stated that it is not a precedent, lordship.
What?
The grade 1 examination of the department is not a precedent. It is not a necessary. Grade 2 is compulsory, lordship. Grade 2 already we have completed.
Grade 3?
Grade 2 already we have completed. Departmental grade 2 exam.
Where is the draft rule?
Lordship will find page number 6 of my petition.
Page
6,
page 6?
para 6.
No, where is the draft rule?
No, I have stated regarding the 2005 draft.
Hmm?
Draft of 2019.
Rule 13 of the 2000 provides for general procedure for promotion to the rank of sub-inspector. No. This is 2035.
Yes, 2005.
They have the 2019 draft rule. Since they were promoted on the base on 13/9/2020, this draft rule of 2019 will apply. Hmm? Where is the requirement? This is Assam Police Communication Service rules. Where is the inspector? Sub-inspector of police, where is
Rule 12 promotion, my lord. 11, 12,
Rule.
yes. Appointment by promoter in the cadre shall be made in the manner provided hereinafter. These are the serial number 4. 75% of the strength of the cadre of sub-inspector shall be filled up by promotion, subject to availability of suitable candidates, provided that any shortfall of this reservation in the cadre due to non-availability of the adequate number of suitable candidates in a particular year shall be carried forward to subsequent years. And promotion, Rule 12, sub-rule
Grade 1 PWCC level 1 course of his trade or equivalent.
Rule 12, my lord, sub-rule 2, clause 2, rule on 2.
222.
Bottom, my lord. For promotion to the rank of sub-inspector of police communication, one must complete 7 years of service as assistant sub-inspector
They
of
have
police.
completed. B, one must pass the grade 1 PWCC level 1 course of his trade
One
or
must
equivalent.
pass grade 1.
You do have that?
After that, I
No, my lord, he
completed.
has not passed.
2018, I completed.
Grade 1.
Yes.
Huh?
Yes.
Where it is?
It is in my petition.
Not petition, why you this completion? How do you say so?
Yes, yes, my lord.
Petitioner was.
So, see, the
My lord,
qualifying year is not a dispute. Only dispute could be the
grade 1.
passing of grade 1.
Lordship, only one.
When did you pass?
That is the criteria, my lord. That is the criteria.
Huh?
But
He
but
was
Supreme
our
Court ruling,
affidavit is-
but Supreme Court
let
ruling
him
is there
complete, my lord.
regarding draft rule, Lordship. I'll produce. My lord,
Okay,
kindly
but the
produce, kindly,
First, whether you have cleared the draft, the grade
one.
order. If you have, what's there? Why you-
page number 24, Lordship.
Page 24.
Yes.
Your writ petition,
Yes.
24.
Annexure D.
Ah,
Lordship will find serial number 6. Gopesh Chandra Deka. The result, in the first line, the result of the 34 grade 1 program for police surveillance service squad, the results.
what is 6 and 7? What is the name of 6 and
6
7?
and 7 is my second, third petition.
Huh? What is the name of the first 6 and 7? Respondent number 7. 6 and 7.
So they earlier completed before me.
Ah.
They completed before me. I completed in 2018, Lordship. 29/9/2018. Their list is not with me, Lordship.
Is it? It is. Is it seniority come merit or merit come seniority?
My lord, our affidavit, my lord, Lordship, kindly see in this case, annexure 1. Regarding your promotion, page 41. Regarding your promotion for from ASI to rank SI. PRO. Application dated 1/6/2020 regarding claiming for promotion to the rank of sub-inspector. I am directed to state that you were appointed APRO in the rank of constable operator in 1984, passed police basic training 1984, passed radio organization so and so. Further, you had failed to attend the training course on PWO grade 1 program at APRO training Jalukbari, Gauhati, even after 3 regular sons given to you with effect from 30th October 2000, 11 June 2001, and 13 February 2002, respectively. You were expressed inability to attend the PRO grade 1 program even in the third and last sons, which was mandatory for promotion to the rank of sub-inspector APRO. As per the draft, the Assam Police Communication Service Rule 2018 you would not get chance to undergo grade 1 training course in future and would not be eligible for next promotion. However, as per your request, you were given a special chance to undergo PWO grade 1 course and directed to report APRO training school, Jalukbari. Subsequently, you had undergone and passed the course with effect from 5/9/2018. He passed after all and special chance 5/9/2018 and dated Iman and availed the benefit of grade 1 pay. He is availing the financial benefit, grade 1. He passed 5/9/2018. The juniors, private hospital was 6 and 7 passed before his date of passing this grade 1. As per draft service rule, you would not get the original seniority of your own batch and your seniority as determined as per date of passing of grade 1 course. In view of the above, your name will be considered for promotion to the rank of sub-inspector in APRO as per present seniority and vacancy in the post-based roster.
Where is the in draft rule where it says that, where is the seniority? Provision for
Seniority, my
seniority,
lord, from the passing of the grade 1.
where it is?
That is, my lord, on that is 5 September 2018.
Where is the provision in the draft rule?
He will be counted. His seniority will be counted.
But where is the provision in the draft rule?
Provision, my lord, draft rule, I will have to go.
Version is prepared and published.
No problem is, my lord, I have not gone any.
The member service.
That was-
Such a-
One must pass the grade 1 PWC level 1 course of his trade or equivalent. One must have satisfactory record of service records so and so. One must be department of promotion, positive so and so. Seniority. Draft seniority rules 21. The seniority of the member of the cadre is recruited by promotion shall be A. Determined according to the order of preference in the respective select list recommended by the selection board and approved by the approving authority if or he joins the appointment within 15 days from the date of receipt of the order and within the extended period. That is the from initial appointment. And the inter-seat seniority of the batch of personnel promoted by one post of cadre to a higher post in the cadre will normally be maintained as per seniority in the earlier post, unless the same is changed by selection board for reasons clearly rendered in writing of the board. So you have reason is given that you did not pass the grade 1. You passed only 5th of September.
That's to be by the selection board, not by the deputy superintendent of police.
No, that's why.
You have replied it only. You have to show that in draft rule, how the seniority, the promoted officers should be maintained. Whether this is based on the clear passing of the grade 1 that exam.
Yes. Whether it will be from direct recruitment, recent direct recruitment or from the passing of the grade 1. Lordship asked me to clarify it.
No, seniority B is very clear.
The interest seniority
of a batch of personnel promoted from one post to so and so.
Yeah.
This will be in respect of ASI.
Will normally be maintained as per the seniority of the earlier post, unless the same is changed by a selection board. So records, I have not gone through a selection board, whether they have accepted it or not.
I don't think so.
For reasons clearly recorded in writing by the board. So
where is the seniority list?
Seniority list, my lord, board list. And our affidavit, my lord, paragraph 11 also we have stated. A candidate will be given 3 chances to undergo a PWCC level, grade 3, grade 2, and grade 1 training course respectively. And the case ends he or she fails to pass particular module of course, he or she will be given maximum supplementary attempts. In eventually the someone of the lower position in the seniority of the list is her batch who has passed duly the level 3 to 1 course, getting promoted to the next higher rank before him or her, the seniority of the supplementary cadre will not be restored to original place of seniority list as per her batch. As per his seniority will be determined from the date of passing level 3, 2, and 1 course within 2 years. That is our step.
Where it is?
So that is, he passed it in 2018. So his seniority come down
How?
because, my lord, he did not pass it, my lord. The seat has,
That is not a
His son's
requirement as per
personal.
your draft rule.
he, yes, that rule is adopted, and he, that is,
No, draft rule doesn't provide so.
that is there, my lord.
That if you don't
Rule 21,
pass
no,
the grade 1,
Rule 21, lordship, can you see?
huh?
Rule 21. That's why, my lord, select list the records, I will have to go through it. Industry seniority based personnel promoted one post of the cadre to a higher post in the cadre will normally be maintained as per seniority in the earlier post. Yes, unless the same is changed by the selection board for reasons clearly recorded in writing by the board. So, lordship, until I go through the selection board records, my lord, I cannot say, my lord, there is no, the provision is there.
No, selection board has to first determine the seniority, where it is.
Actually, they will determine when he passed the grade 1. Definitely, my lord.
See, your draft rule doesn't provide that it should be based seniority, it should be maintained based on the passing of the grade 1.
That was, my lord.
How can you have that kind of
Rule
decision?
21. I have not gone through all these things. my lord.
And
He's assisting me, my
see,
lord, but
Mr.
that is-
Chutia, the not passing within I mean, for not appearing in 3 times chances, losing 3 times chances, it's a fait accompli
Lordship.
because you have allowed him to
Or lordship.
undergo.
Yes,
He has passed it, you have shown, you have declared the result.
yes.
So availability of vacancies is concerned, my lord. Whether there's
The issue
vacancy
is, admittedly, the respondent 6 and 7, whom you have promoted, they are admittedly junior to him. So far as the post of
sub-inspector.
assistant sub-inspector is concerned. Now you need to, and there's nothing to show that he is not fit. Of course, had he not passed the grade 1 in 2018, because you have promoted the respondent number, the private respondent who is junior
Yes,
in the year 2020.
Yes.
20.
Ah.
My lord, no, my lord, they have promoted it to 20, but they have passed before that.
No, passing is, they may have passed earlier, but it is not a criteria for, determining the seniority.
No, it is a criteria.
No.
Rule 21 says, my lord, the
No.
selection board will see until and unless, my lord, there is other reasons. Otherwise, my lord, seniority will come from the date of initially recruitment.
Yes.
That is true.
How you
But
can
there is a
have that?
criteria to pass the level 3, level 2, and level 1 course. So petitioner,
As per the seniority in the
Having
earlier
given-
post,
having
unless the
given
same is
reason.
changed by the selection board, reasons clearly recorded in writing by the board.
so he was given
You
reasons.
show us that his seniority has been altered.
That's why I will have to go through the records. The records I have not.
And there is no, nothing,
In fact, I have not gone through the contents of
there
petition, my lord.
cannot be any, I'm sure selection board has not taken any decision.
I cannot say, my lord, today. Let it be on Thursday, my lord. I will clear it on this day. Individually, I will have a chance to go through the contents of
Thursday.
the petition. Yes.
Okay. And Mr. Thursday,
DKD.
DK, the Land Council for the petitioners. Next,
Okay,
para,
well,
after hearing the matter at some length, it is seen that as per seniority, as per draft recruitment rule, Arunachal Pradesh Communication Service Rules 2019. The determination of seniority, seniority of the batch of personnel promoted from one post of the cadre to a higher post in the cadre would normally be maintained as per the seniority in the earlier post, unless the same is changed by the selection board for reasons clearly recorded in writing by the board. List of confronted with such provision about Mr. P.C. Chutia, Leonard State Council submits that he may be granted to obtain instruction and as well as the record as to whether there's any decision or by the selection board changing the entity seniority of the parties with the reasons in writing. List of next para. Considering the other issues being not disputed and the determination of seniority appears to be a bone of contention as of this stage, comma, let these matters be listed on Thursday.
Thursday.
Thursday is what?
Tuesday, my lord, next week, there's
06. No, Thursday.
Thursday. Thursday, that means, my lord,
06.
6,
Day after tomorrow.
Friday. Oh, okay.
Huh?
Lordship, make it Friday.
Friday, my lord.
Why Friday?
7th of
6.
6.
Yes, ask, have a talk today itself and ask for the record whether there is a decision of the board,
Yes,
election board or
board.
not. That's all. I'm sure.
Obliged, my lord.
I'm sure there will be no decision.
Lordship, I have a small prayer, Lordship.
Huh.
So far the draft rule is concerned, Supreme Court says it is not a precedent. I have a judgment, Lordship.
You
That I will brought
you
his
keep the judgment with yourself.
Lordship.
My lord, he
When the recruitment rule is not finalized
Lordship.
and the first has to be filled up, there is no bar to go as per the draft rule. That is also equally settled by the Supreme Court, not by me.
my lord, he will
and
provide
moreover-
That is
access.
context.
And
You
moreover,
will have to
2000
see.
And moreover, 2013 notification is there,
See,
Lordship.
we'll have to remind
Their
ourselves.
own notification.
Every judgment is not, we cannot treat it as like the Euclid's theorem. It depends on case to case, facts to facts.
আছে কপি আছে
Yes, next.
অবলাইজ বলে মই
Obliged.
লিখি লওঁ হা এইটো নোট কৰি দিয়কচোন, লিখি দিয়ক।
Was the petitioner has not been appearing since 2017.
Why she is not entitled?
Manoj, there is an OM that we have mentioned in our affidavit. An OM that we have mentioned in our affidavit. Para number 9. Manoj.
Page.
Page is
Affidavit on behalf of respondent number 2.
respondent number 2. Yes, Manoj.
Yes.
Para number
Para 9.
9, Manoj.
Yes.
Manoj, if I may read from the 4th para.
Read
line,
everything.
fourth
Read
line.
everything.
Manoj,
Read from the beginning.
that
You
the
please
state-
read from the beginning.
Manoj, that the statement made in paragraph 10, 11 and 12 of the petition, the deponent begs to state that as per government OM number so-and-so dated so-and-so, special family pension is admissible to relatives of government servants who is skilled in discharge or in connection with discharge of duties. Further, in the Government of Assam Finance Department's OM issued subsequently wide this number and this date, it was clarified that cases of death
injury, disablement caused due to accident are not entitled to special family pension in terms of the OM. Only the families of government servants who dies while performing duties in connection with discharge of duties as a result of attack by any extremist antisocial elements, etc., or during action against dacoits, smugglers, hostiles, or other antisocial elements will be entitled to the special family pension in terms of the OM dated this. Now, my lords, the accident due to which the petitioner's son had passed away.
This
It
case
was-
may be dealt as per the extraordinary pension rule. Have you dealt with the extraordinary pension rule?
That's
You have said, therefore, this case may be dealt as per the extraordinary pension rule 1963.
Lords, the death of the petitioner's son was due to a buffalo attack, which was an accident.
You read entire paragraph, that's what I'm saying. Suppose if she is not entitled
My lords.
under the family pension, the thing, she would be considered under the provision of extraordinary pension rules 1960. Have you done so?
No, my lords, I need to take instructions on this matter in this regard.
Not appear. Otherwise, could have dismissed, but it's a poor lady.
My lords.
Her son has died while on duty. Okay. Non appears for the petition on call. Next para. Mr.
S. Sharma, my lords.
S. Sharma, Land Council,
On behalf of respondent number 1 to 4, 6 and 7, Forest Department.
Standing Council.
No, my lords. On behalf of D. Gogol.
We go over Land Council for the Forest Department. Press for is granted. 3 weeks time to obtain instructions. List after 3 weeks.
Well,
None appears for the petitioners on call. You are appearing for?
I am for private respondents number 5 and 6, my lord.
Who are you?
I'm for responding number 1 and 2 lots.
I am,
There's no, grievance against you.
there is no grievance, there is no as such grievance, but what they have, my lord, sought to bring an analogy here is that if private respondents number 5 and 6 are to be conferred with higher time pay scale, they also should
Sorry.
be given the same benefit.
Why not them? Why not to them also?
Why not to them also? But
Yes.
my lord, here, one development that I beg to apprise this honorable court about is, we have in fact withdrawn our claim for higher time space. And the litigation that we were pursuing, we have withdrawn that case. In fact, these two matters were earlier tagged together also.
You have given a go by to that, your claim
Yes,
of higher pay scale.
yes, and we have apprised this honorable court, we have withdrawn our
And
case.
Mr. You read, and Miss, non appears for the petitioners on call. Next para, Mr. A. Chakraborty, Land State Council, as well as Mr.
D. Chakraborty.
T.
5 and
Chakraborty,
6.
Land Council for responding number
5 and 6.
5 and 6 are present. Next para. Having considered the grievance raised in this writ petition, as which to the extent the having in this petition which pertains to claim of similar pay scale,
Higher
Base-
time pay.
higher time pay scale with the respondent number 6 and 7,
5 and
5 and 6, which has been given a go by the respondent number 7, C5 and 6. So it appears that the petitioners are no longer interested to pursue this matter. Accordingly,
May I be allowed to please this order, ma'am? The order by which.
for non-prosecution. No, it's okay.
Ma'am.
You are
Deeply,
dismissing on non-prosecution.
deeply opposed.
Item 9.
Yung mo akhir of the. Excuse me. Yes, yeah. It's also 2016. Non-appears for the non-appears for the parties on call. Next, considering that the matter pertains to selection, public recruitment of lower division assistant cum typist, which has been in the year 2016. The petitioners appears to be no longer interested to pursue this matter. Yes, accordingly, the petition is then dismissed for non-prosecution.
Item 10.
In this case, I need some time. We have not filed our affidavit, madam.
What is the matter about?
Regarding my
Lordship, the lower of grade pay, your lordship.
Udit Narayan.
Would it-
Huh?
Yes, lordship. The petitioners aim, your lordship.
You need some, so I mean,
affidavit does not
affidavit
be-
would be required.
Pardon?
Affidavit would be required.
Yes, lordship,
Yes.
because
And Mr.
certain things, DJ Das is.
DJ Das,
Yes.
learn counsel for the petitioner. Petitioners, which post?
Lordship,
Which post?
lordship, we are the trained graduate teachers, your lordship.
Okay, training as a teacher. As prayed for by Mr.
PK Boramal.
PK Bora, learn
Respondent
counsel
number
for the,
1 and 4, madam.
State Council,
The
Standing Council,
Elementary Division.
Division Department, and Mr. P. Alia, H. Alia, learned Standing Council for Finance Department. Further 3 weeks' time is granted to file affidavit in opposition. Finance will be required.
Lordship, otherwise this case is covered, Lordship, where
Yes.
the honorable division bench has held that the assistant professors they won't be entitled to the great pay, Lordship. I will produce that.
Let them bring by way of affidavit, your lordship, because I will also get a chance to revert back.
No. Do you have the judgment?
No, I have.
You have the
I have
judgment?
number.
Yes, I have the WPC number, yes, Lord. I don't have, I'm not.
Lordship, that order we have already announced here, lordship, the interim order, not the final order.
No, final,
WPC
you said
59
final order.
Yeah, final order is in read appeal, your lordship.
That's been disposed of.
Yes, Lord, that is
Nothing
disposal, but in
remains.
what light, that I am not aware of, your lordship.
Lordship, let them file the affidavit. I'll produce
No,
it.
no, Friday. Friday will dispose it off. If it is, if the same is been decided by division, what remains?
Lordship,
Why
let me
unnecessary
also
troubling
go to
the-
the order of the division bench, your
Huh?
lordship. Let me also go through the order of
Give
the
him
division bench.
WPC number, Lordship, we can. Lordship, in the meantime, let the education department file the affidavit. If some-
No, if the matter is already settled by
Yes,
division
Lordship,
bench, what
otherwise
remains
Yes,
there?
lordship, if education department has to say something that
No,
it's a
no,
different.
definitely they will
Yes,
take
and
the,
Lordship,
take
That stand is more important, your lordship, education.
why unnecessary troubling them when the matter is already decided by the division bench?
Lordship, next week,
Anyway,
lordship, the date.
3 weeks.
Much of this. Obliged.
Item 12.
Don't touch.
Item 12.
With this meeting. Okay, 2020. Now appears for the parties on call list after 4 weeks.
Item 16. Okay.
Lordship.
Yes,
Matter may be passed over for the time being, Lordship.
Why?
My senior Mr. H.K. Das is on legs in another.
Hmm?
My senior Mr. H.K. Das is on legs in another court, Lordship. After some time, Lordship.
what is the matter about?
Lordship, non-granting of resignation and claim of compensation to the tune of rupees 35 lakhs. The petitioner was is a doctor, Lordship, and she had
Art MS so-and-so learned counsel for the petitioner. Who is appearing for state? As Boro learned.
Lordship, for the time being, Lordship, my senior is coming, Lordship.
Admit list for hearing after 3 weeks.
Lordship is just on legs, Lordship is coming, Lordship.
Tell her, tell him. We'll fix it for hearing. You give the date after 3 weeks.
Lordship,
I am for respondent number 8.
Hmm.
after some time, Lordship.
Huh?
After some time,
What after some time? We'll fix it for hearing. Just inform, tell him. Hmm.
Lordship.
Item 19.
Any difficulty, let him come. And I pass the order. Fix, we would not, if you want fixed date, we'll give you the fixed date. That's all. After 3 weeks, you just give the date.
Next week, Lordship.
Not next week, after 2 weeks. 20 August.
August. Lordship.
Hmm.
Obliged.
But any difficulty, you will let us know.
Could it be on 25th, Lordship?
25th. Huh? Make it 25th.
Obliged, Lordship.
But then if your senior has difficulty, come back. We'll see.
Lordship.
But we're not taking up today. In any case.
Obliged.
May I please, your lordship?
Yes.
Lordship, we are grade 4 employee, my lordship. Employee.
What do you want?
Similarly situated persons, my lordship, they have been given minimum pay scale.
Lordship, here my learned friend is relying on Upenda's lordship. That has been set aside recently. So but the grant of minimum of the pay scale, lordship, there are other judgments also where. Yes. Yes, lordship, lordship. Here now the issue is, lordship, so on that line we are providing, but in the case of the petitioners, we have not received the proposal from the administrative department, the employees. Lordship, I have a communication where we are asking for the information because other departments have forwarded their names. There a list has been prepared, which is waiting final approval, lordship.
Who is for your department? Who is for?
Women and Child Development Department.
As for our affidavit, lordship, they stated that however the finance department rejected the proposal. And
That was in the year 23, lordship. Now, lordship, pursuant to this affidavit, there was another notification where we had again asked, and recently, even now we are getting the names who are eligible for minimum of the pay scale as per Jagdeep Singh, your lordship. Those names should be forwarded by the department. So this instruction is perhaps requires to be updated, lordship, as to the recent whether
After the instruction, you send this.
I have a communication, lordship. I'll
Send his name.
after the present.
Huh? When next week?
There is not dispute, we are working. There is no dispute regarding our appointment and our continuous work, my lordship. Finance department rejected, no reason was.
That was in 23, lordship, there was a notification, finance department issued a notification. There was a sunset clause where after the departments were informed to send the name of the muster roll workers, one-time measure was taken, lordship, pursuant to Upenda's. So though pursuant to then finance department set a cutoff date that after so and so date, we will not accept any proposals for minimum of the pay scale. That was set aside, Lordship. So after that, we sent another communication to all the departments to again, as per the directions of Jagdeep Singh, we communicated to all the departments, then kindly forward all the names again. And now their names have not been forwarded, Lordship. Yes.
Where is that notification?
That has been set aside, Lordship, sunset clause. Now they just, if their petitioners are eligible, they just need to forward their names because we already have a name that is pending final approval.
It is you to
Yes.
forward the name.
And regarding that, Lordship, we have sent reminders in 25 and 26 also. We have stated that in our communication, Lordship. I've just handed my learned friend the copy.
Let's see.
Yeah, Lordship. It's अपना 23 episode. 23 in fact, something.
This is different case.
Lordship, there are two cases. Namuddin, 18, 19?
Two cases, 18 and 19, my lord.
Yes. There are.
No, this is your communication seeking parents' comment to the.
Regarding the petitioner's status, Lordship, we have asked for the status of the petitioners. That whether they have rejected, whether they have forwarded, whether they are considering, we have not received anything from the department. So if my learned friend can get a instruction on this letter only, which we have sent to the Women and Child Development, Lordship, then we can expedite the
And
process.
Mr.
SB.
SB, or should we dispose of the matter directing you to department to forward their names?
Lordship, after considering, or Lordship will give us the-
Verification, they can.
Yes, verification task
they
may
can
be
do,
given.
my
Yes,
lordship.
After verification, Lordship.
Yes, my
If
lord.
they are eligible, they may pass an order, and my learned friend can obviously, if it's rejected, he can
Without
always.
verification, they can't give, they can verify and.
Yes, Lordship, that can be done.
Then we'll dispose it. On the basis of Jagdish Singh,
Yes, their cases will be
or
considered.
Mr. SB Laskar. 18 and 19,
Yes,
My lord.
learned counsel for the petitioners. And also heard Mr. H.L.E. learned
Finance Department.
finance department, learned standing on finance department, as well as Mr.
H. Chakraborty for respondent number 1, 3, 4, 5, and 6.
H. Chakraborty, standing counsel.
Yes.
Only number?
1, 3, 4, 5, and 6 in item
1, 3,
number
4.
18, Lordship.
We'll direct the department to.
Yes, Lordship.
Forward the name to the
If they are eligible,
finance
in line
department
of Jagjeet Singh, Lordship.
after verification. Dispose of.
Lordship, for verification, a timeline of at least 3 months may be granted, Lordship.
3 months.
And let them serve a individual representation, Lordship, in line of Sukhendu judgment, because for consideration, let them file an individual representation.
You file
for
a
the department,
representation also.
And it will be easier for the.
20. Item 20.
Lordship, here I have challenged my lordship impugn termination order, my lordship, which is on page 13, my lordship. My contention is that principles of natural justice has not been followed, my lordship. Here only saying that have been found in an untoward incident. And nothing has been stated what untoward incident, my lord, nothing. So it is a, my lord, stigmatic, my lordship. On that ground only I have challenged that. It has been found involved in an untoward incident that had taken place in 7/1/2021 during the field visit undertaken by S.L. Lashkar, Joint Director, my lordship. No show cause notice, nothing, my lord.
What is the additional affidavit?
My lordship, additional affidavit with the, it's my initial terms.
Are you a regular employee?
Oh, my lordship,
Then-
contractual, my lordship.
Huh?
Contractual, my
Then-
initial appointment was contractual, my lordship.
Then-
Time to time, it has been extended, my lordship.
So, where is the termination?
My lordship, termination, my lordship, on the basis of my lordship, it's a, and principles of natural justice, my lordship, has not.
What principle of natural justice?
Untoward is stigmatic also, my lordship, because untoward incident, at least they should say, my lordship, what is the untoward incident, my lordship. And the termination is regarding serious misconduct and gross indiscipline, my lordship. If it is serious.
Where is your contract?
My lordship,
appointment
contract I have
engagement?
submitted as a additional affidavit, my lordship. On flag A, my lordship. Let me see. It's a contract of 2010. That is was when I was initially engaged on contractual basis, and
What
thereafter.
what is the termination clause?
The duration of contract, resignation, my lord. Termination of contract clause 11, my lordship. The agency reserves the right to
Involve
terminate
any of the indisciplinary misconduct or contextual step one to into any of that may be clause. Yes, there is.
Yes, my lordship.
If the conduct is found to be involved in any act of indiscipline misconduct, that's all.
Yes, my lordship. But my contention is that, my lordship, this termination letter, my lordship, what misconduct at least I have done, my lordship, and what involved that is nothing has been stated, my lordship. Kindly see, untoward incident, and I have been terminated, my lordship.
Yes, what is your stand?
Lordship, firstly, in being a contractual employee, his termination is as per clause 11, which your lordship has just read. That if there is any misconduct, the concerned employer has the right to terminate him. The second point would be that the termination order is of 2019. He has challenged it in the year 2023. That is after 4 years.
Have you filed the affidavit?
Lordship, no affidavit has been filed.
I have representation I have done, submitted, and I was pursuing before the department. After exhausting all the other alternative remedies, my lordship, I have approved, my lordship.
Notice was not given.
Nothing, but my lordship. Only untoward incident. they
Did
have
you
stated.
file the affidavit?
Lordship, no affidavit has been filed on our behalf.
Huh?
We haven't filed any affidavit.
Matter of 2023, my lordship.
Lordship, but in a similar case of termination of a contractual employee, there's a decision of this High Court itself.
There's so many decisions,
Lordship,
depends on case to case.
Lordship, the question is,
There's so many decisions against you also. And Mr. S.B. Laskar, learned counsel for the petitioner. Next para, as prayed for Mr.
A.K. Ghosh,
A.K. Ghosh, learned counsel,
on behalf of Mr. K. Kumar.
appearing on behalf of Mr.
K. Kumar,
K. Kaur, learned
additionally,
additional advocate general for this, for that 3 weeks time is granted to file affidavit.
The date may be fixed, my lordship.
You'll see. Let them file first.
Highly obliged, my lord.
Lordship.
21.
In this matter, I appear for respondent number 1 and 2, Employees Provident Fund Office Lordship. We have sent the affidavit in opposition for vetting.
And
We
Mr.
Further time.
All Oscar. All Oscar.
Laskar, learned counsel
The
for
date may be fixed, my lord.
on the prayer of Miss M.S.
A. Chakraborty.
H. Chakraborty, learned counsel for,
After 3 weeks, any
learned counsel for respondent number
1 and 2.
1 and 2. For the 3 weeks time is granted to file affidavit.
Date may be given.
3 weeks.
Obliged.
22.
May it be given.
Yes.
Lordship, the issue is here is non-communication of ACR and denying lordship, consequently denying lordship the promotion to the
Yes.
petitioner lordship. And the petitioner is working in BSF and lordship in terms of the debt cut and others lordship, the communication of ACR is required. That has not been done. And other ground is lordship that before giving any lordship adverse remark, some counseling, warning, etc. has to be given. That has also not been given. These are the mainly two grounds. And lordship may come to the so-called purported adverse remark, lordship, though it is given very good. Yeah.
Page.
Page 36, lordship, is the so-called lordship, the adverse remark. It is merely a statement without a vague statement without any incident, nothing. Thereafter, they have neither communicated it nor given me warning, lordship. And lordship, number of judgments are there, where lordships also passed similar judgments also. Page 36 is the lordship. This is the purported lordship. May I read this, lordship? Well qualified radio operator, he needs to be accompanied with colleagues and understand as well as realize their pain in force. Although individual must be given his dedication and become worthy in the allied force, overall, SO is granted very good. He has been granted very good. But on the basis of this statement, so-called statement, I mean, they have denied me promotion and this has not been.
What is the benchmark?
Benchmark, lordship, that good, very good. That is also benchmark is there.
What do you mean by bit good, very good?
Very good, lordship. I have
Then
mentioned.
if it's, what's their adverse?
Lordship.
What adverse it is?
Yeah, it is not adverse, but they have saying there in the affidavit, they have said this is adverse.
No, their affidavit will not do.
Lordship.
On the basis of this, you have, although you have the graded as good,
Very good.
you have not been promoted.
No, not promoted, not communicated, nothing. This remark has not been communicated to me at any point of time.
See, whether this, while taking up your promotion, whether this grading has been taken not of or what?
Yes.
It has been taken into consideration.
Yes, Lordship.
And if the grade was, benchmark is very good.
Very good, yes. But
then you have been graded very good.
That is the question, Lordship. How they are, Lordship, denying me, it's their Lordship part.
So it's not question of non-communication.
No, that is very bad. That is also there, but that has not been communicated also.
No, communicate, forget about that. Otherwise,
yes, otherwise I am eligible.
Then,
but they have denied.
Yes, madam.
Hello. That adverse remark is in page number 172 of my affidavit in opposition, my lord.
Hmm. Hmm. 72, 172.
My lord.
Yes,
Here, my lord, kindly see the
same thing. Which he has shown.
Same that.
it's same thing, my lord.
Well qualified radio operator, he
Yes.
needs to be accompanied with the colleagues and understand as well as realize their pain in the force. Although individual must be given his dedication, become worthy in elite force. Overall, SO graded very good.
My lord, grade is different and opinion is different. My lord, for this, my lord, kindly come to page number 74 of his petition, my lord.
17.
74, my lord.
Hmm.
0.26, my lord.
Hmm.
The report should neither contain any assessment pertaining to a period prior or subsequent to the reporting period, nor should the assessment be based on the single or isolated incident. If the initiating reporting officer has insufficient personal knowledge about the, we should not be hesitant to say, it is it is responsibility of the
Hesitate to say so and should not endorse any of the report, huh? It is responsibility of the initiative still concerned.
No, madam, kindly come from 2.25, my lord. Clause 2.25, 74, my lord.
Hmm.
Madam, this is the responsibility of the initiating officer to give his opinion, my lord. As per clause 2.25 and 2.26, my lord.
So,
So, my lord, he given his opinion, my lord, that is one of the criteria for the promotion, my lord.
hmm.
And this is, according to him also, this is also adverse remark, my lord. Against that adverse remark, my lord, he has filed one application, my lord. Kindly come to page number 177, my lord.
Hmm. So it's an adverse remark.
Adverse remark, my lord.
This statement is adverse.
This statement is adverse, my lord.
So,
So, my lord, that is, so he is not eligible for the promotion, my lord.
Hmm.
That has been communicated, my lord. Kindly see communication is, my lord, in page number 175, my lord. One seventy-five, my lord. This is certified that this APR for the period of 20 to 23 has been disclosed to the officer reported upon Kamlesh Taluka, that is the petitioner, and all action in compliance to the DOPT-ON, that is 14 May, in connection with the annual performance appraisal report of the officer have been completed, my lord. He has been communicated, my lord, against the about his adverse remark, my lord.
how?
My lord, this is, my lord, this is the certified that has been written disclosed of the disclosed. Kindly say disclosed.
This certificate appears shown for the periods to so and so been disclosed to the officer reported upon. Kamlesh.
Yes, my lord. And Kamlesh Taluka is the petitioner here, my lord.
By which
And my lord,
which documents has been communicated?
my lord, after
It says it has been disclosed to the officer.
my lord, after that receiving that, he filed that his representation also, my lord. Can you see page number 177, my lord?
Hmm.
That means he admitted that he know about that his about his adverse remark, my lord. 177 is the his representation against this adverse remark, my lord.
Expansion. To expunge.
Yes, my lord.
Hmm.
Yes. Okay, welcome to that. Regarding this communication, the manner in which a lordship adverse remark is to be communicated has been mentioned at page lordship may come to. Page
We'll resume after 5 minutes.
lots.
Hearing,
Already, Lordship may require, may hear it, but Lordship, the same similar squarely covered case, DSF, same institution, Lordship. Honorary Division Bench of the Delhi High Court has, Lordship, given the order, Lordship, passed the order, saying that the way, the manner in which my friend colleague is saying that it has been communicated, Lordship, Lordship may come to the guideline. How
that's
it has-
okay. That's what I'm saying. It takes time. It will take some time.
Lordship, it may not take much time, 20 minutes, so only 20 minutes will do, because if Lordship plays the judgment, it's there within the file itself I've given. If Lordship goes to that judgment, then everything is covered.
Next week, we'll take it up next week.
Lordship.
And Mr. A. Tabil learned consent for the petitioner. And also had MS again done his CGC. That this matter be listed after a week.
Yeah, get a date, Lordship.
Tuesday, next Tuesday,
11.
11, huh?
11.
Lordship.
Sure. If you have difficulty, let me know. Huh? Small orders too. Yes.
Supplementary
What is it? Part harder, Lordship?
No, will not part. Actually, I have some personal difficulty
Or not?
in this state. Not serious, but then
No, Lordship.
kind of little irritating, problem I'm having.
No, Lordship.
Not serious.
It's
That's why I have to be.
Supplementary.
Huh.
obliged, Lordship.
I want to withdraw it to file a fresh, my lord, with liberty, my lord.
Mr.
A.Y. Chaudhary.
A.Y. Chaudhary, learned counsel for the petitioner. Press for withdrawal of this writ petition with a liberty to file a fresh. Liberty,
Yes, my lord.
Mr.
A.K. Goswami.
J.K. Goswami, learned
Additional senior government.
additional senior government advocate is present according to writ petition stands clause on withdrawal with a liberty as straightforward. Yes, Lord.
Item 24, orders.
This contemplation is not maintainable as because it is not abstract. Section 20 of the Contempt Act 1971. As because, my lord, the main writ petition was disposed of 12/9/2007, and he was filed a contempt on 2019. Man.
Now it appears for the petitioner on call. Mr. You're for Alice contender.
Yes,
Whether you have complied with or not, forget about technicalities.
my lord. Now process is going on regarding that, my lord.
What?
It is examining the matter.
Let us see the order.
Yes.
Where is the order? Where is the order?
My lord, here, actually.
Sir, you are representing Alice contender. Be serious.
My lord, contemplation has.
This court is little lenient, doesn't mean that you will take advantage of that. Release the salary of the petitioner for period he served in the school from so and so. This is refundable amount due from the earlier salary in terms of the order shall be paid to him. 6 months. In that case, what I said, not appears for the petition on call. You shall not counsel for Alice contender is present. It is seen that on the last date of listing. Petitioner was also remained unrepresented. However, considering that the list container has list container appears to have not complied with the order of this court. Let this matter be listed after 3 weeks.
4 weeks.
3 weeks. In the meantime, whatever you want to do it. There's a clear direction. Payment of salary.
Yes, madam. But he actually, my lord, he has caused the limit, he has not filed the contempt petition within the limitation.
It's okay. Technically, I'm saying we may not go into it. When you found that you have not done it, we'll see. Yes.
26. 26 item. Item 26 lawsuits. Perhaps this matter, this whole contempt may become infraction because lawsuits, this contempt was filed against the order dated lawsuit 27/1/2020 passed in WPC number 480/2022. Look at Annexure 1, page 11. And here lawsuit the petitioner sought his seeking a sought provisionalization lawsuit as per the 2011 Act. And thereafter lawsuit he has filed another case lawsuit WPC number 1612/2025. Which was disposed on 15/9/2020. Here, he sought his permission under 2017 Act, this is the present Act. That's why lawsuit in this contempt was under requisition, he is not pursuing lawsuit. In last occasion, he did
Subsequent,
yes,
subsequent,
he filed another requisition. This is
there's the order.
this is the order.
No, it appears for the petitioner on call.
This is a subsequent case.
Same person.
Same person lawsuit. Name, father's name,
After-
village, same person.
The order dated. Mr. Hauber, huh? Mr. SMPCC Learned Counsel for the LS Continuer is present. Subsequently, order dated 27/1/2020. It appears that the petitioner has filed the WPC 1612 of 2025. Whereby
Yeah, the second case file was it 1612/2025. No copy to issue wait. Same 17 Act of course.
whereby this code has whereby this code by the order dated 15/09/2025 has directed the authorities to consider the service of the petitioner for promotional after completion of the necessary verification in accordance with the law. In view of above, there's no willful violation of the court's orders. Accordingly, contempt petition stands closed. The copy of the order dated. It's okay.
Lordship, kindly my name may be referred, Lordship.
Okay.
NZ Chaudhary, Lordship.
So there's nothing.
Lordship, that's from by Lands Council.
The record is there.
I am for 1 and 2. Both corresponding.
Then you have to write
1612.
Mr.
NZ Chaudhary.
NZ.
Chaudhary.
NZ.
Yes, Lordship.
Chaudhary Learned Counsel for the petitioner is present. And no, Learned Counsel for the petitioner and Mr. SMTCC Learned Counsel for Alice Contemner Alice Contemner number 1 and 2.
1 and 2.
Are present, huh? Then you write that. Huh? Yes, next.
27. Yeah, 27, we have issued a compliance order. I am giving a copy to him, and also this is just to the Lordship, we have
And Mr. N.J. Chaudhary, learned counsel for the petitioner. Mr. S.M.T. Sisti, learned counsel appearing
1 and 2.
learned correspondent Alice contempt number 1 and 2 by placing the communication dated 05/05/2022 by the Director of Secondary Education, Assam, as submitted that the order dated
Lordship, here the order dated Lordship,
27/1/2020.
yes, Lordship.
Passed in WPC 4627 of 2020. Has they been complied with? Accordingly, the contempt petition stands closed. Please that the copy of the communication so and so is kept on record and marked as document X.
29. That's all right.
28 to Hamlin only. 28. Here I have received from instruction from the Lodging Inspector of School, sir. Here on last occasion, Honorable Court has directed me to whether that amount was actually deposited or not. That instruction was there. So it was deposited, Lordship, that amount of 88,148. White Treasury Salan bill number so and so dated 26/2026. That was deposited in the account of the Lordship, response number 1. Now they have to deposit to the petitioner, Lordship. Hey, come get it.
We'll say complied with.
Let me get the instruction whether the petitioner
I will comply.
not
Jason. You take instruction. You tell him.
There is a treasury bill number and that is also there, Lordship.
Heard Mr.
PK Das.
P.K. Das, learned counsel for the petition. Mr. S.M.T. Sisti, learned counsel for the Alice containers.
2, 3, 4, 5, and 6, Lordship.
Alice containers.
3, 4, 5, and
By placing the communication dated 03/08/2026 from the Inspector of Schools, CDC Silchar, submits that order of this code dated 05. Order of this code has duly been complied with. Accordingly, contempt petition stands closed. The copy of the so and so 03/08/20 is kept on record and marked as document X. Record is. Record her name. What's your name?
Treasury bill number with the account.
Shibu got it. Got the order correctly. Comfortable. Huh? You tell me if you are not clear. Huh? Close.
Okay.
29. Also, I'm applying for respondent number 5, the Lordship. The order has been complied with, the Lordship. So we need 1 week time to place the order.
Where it is?
Lordship.
Where is the order? Compliance.
We need 1 week time, your Lordship, to place.
You
the
have
order.
complied with.
Yes, your Lordship.
Now it appears for the petitioner on call. Next madam, Mr.
S. Alam,
S. Alam, learned counsel for the.
appearing on behalf of MAI Hussain, your Lordship.
Huh?
Appearing on behalf of MAI Hussain.
Appearing on behalf of Mr. M.A.I. Hussain,
Yes.
learned counsel for the list contemner. All.
Appearing for respondent number 5, your Lordship.
Learned counsel for the list contempt number 5 submits that the order of this court dated so and so. Order of this court dated 25/09/2019, passed in WPC 7256 of 2019, has duly been complied with. Accordingly, contempt petition stands closed. Dispose. Close means disposed.
33 and 34. Lordship, in item number 34, office note dated 31/7/2026 says service upon the respondent number 4 is awaited, Lordship.
And Mr.
I am R Islam.
R. Islam Land Constable. Await service report in respect of respondent number
4.
Alice Contemporary number 4.
I'm for the respondent number 2.
Mr.
D Deca.
D. Dekha, Land Counsel for the
Respondent number 2.
Land Counsel for Alice Contemporary number 2 and Mr. H. Alia for Land Counsel for Alice Contemporary number 3 are present.
Yes. Live.
35.
Lord, here we are, I'm entering appearance for 1 and 2.
Okay.
Both the respondents, we need some time to file our affidavit, ma'am.
Had MS
SB Chaudhary.
SB Chaudhary Land Counsel for Mr. Mr.
1 and 2.
Mr.
Arthur, ma'am.
Arthur, sorry. You already entered appearance.
My lord, that.
On the prayer, Mr. Arthur, Land Counsel for Alice Contemporary number 1. 3 weeks time is granted to file affidavit.
My lord, the date may be fixed, otherwise.
3 weeks. Give the 3 weeks after 3 weeks.
25th August.
Item 40 for hearing.
Lordship, in this case, Lordship, one core issue is related to this case. Is the core issue is that who is the original?
Whether he is a permanent
Yes.
resident of the state of
who is the
Assam.
Original inhabitants of Assam, Lordship. On that count, Lordship, we asked to the government to clarify the specific word. It is original inhabitants of Assam. They took some time also.
Took some time?
6 something, yes.
My lord, although in the last order it was directed to file.
He said no further adjournment.
Fine.
What to do? It's for hearing.
Lordship, fixed for hearing, Lordship, but so far, Lordship, the issue is such a nature which one clarification from the government is required, Lordship, for adjudication of this case, Lordship, regarding the original inhabitants of Assam, Lordship. We cannot submit anything, Lordship. It is difficult for us that to submit without the clear clarification from the government.
Yes, this is what 16.7 you have agreed that no further adjournment shall be so.
Yes, Lordship, but so far, Lordship, due to the floods, Lordship, in now what
Are you ready to argue the matter?
My lord, the engaged counsel, we had applied for a VC link, my lord, in due time. However, the link has not been provided to us. My lord. We had applied in due time.
The matter, Lordship, in the
And Mr.
N. Sharma, my lord.
And Sir Malan Council for Petition. Although this court had observed on 16/07/2026 that no further adjournment shall be sought for in the matter by either of the parties, considering the submissions of Land Council Mr. J.K. Goswami And also, in view of the also having regard to the issue involved in the state petition further 2 weeks time is granted to Mr. Goswami, the additional senior government advocate, to take to file affidavit as directed by this court on 16/07/2026. List the matter after 2 weeks.
My lord, may I pray for 20th of August?
20.
20, my lord.
20.
20, Lordship. Can it be, Lordship, 3rd of September, Lordship?
No, 20. You have sought for 2 weeks only.
Lordship, 2 weeks, they will file us.
No. 2 weeks.
Lordship,
Yes, there is the order. We could not have granted you.
Lordship, but Lordship, so far, Lordship.
Sorry,
we
thank
got
you.
the instruction within 2 weeks, Lordship. Thereafter.
You have sought for 2 weeks only.
For instruction, Lordship.
No.
After that, I.
See, last order, you have agreed not to take adjournment. Please send it, give it back. Normally, it's not done. Once we pass the judicial order, no further adjournment. But then somehow we are.
Issue is, Lordship. That's why.
Item 41.
Deeply obliged, my lord.
Bad to your lordship.
Matter has become in process.
No. I have been dismissed from service, my lord.
Ah.
Listed for final hearing. It's very much alive, my lord. My lord, it is only on a small point.
Where is this?
My lord, the petitioner, while serving as a.
Where is the respondent?
The respondent is government, the mighty government, my lord.
Huh?
The mighty government who has dismissed me from service.
Yes, Goswami. We'll take it up at 2 o'clock.
Yes, sir.
Good. Arrange whoever is there. Any other? I just got.
At 2.
At 2.
Deeply obliged.
We just keep that thing. That 2 is the red petition. Supposed to be disposed. I mean, dictated in chair. You just keep it.
Right, please, your lordship. The petitioner before your lordship is assailing the dismissal order, which has been imposed upon him pursuant to a departmental proceeding. In the humble submission of the petitioner, my lord, the so-called notice itself was vague as there was no specific charge. And apart from that, my lord, there is predetermination of guilt by the disciplinary authority while imposing the impugned penalty, my lord. My lord, the petitioner, while serving as a Assistant Sub-Inspector of Police, unarmed branch, was posted at Boko, wherein he was IO of a particular case. And the wife of that accused lodged an FIR stating that the petitioner demanded illegal gratification from her. And accordingly, a trap procedure was laid down. And my lord, one Faninder Das, a hotel owner, he was arrested while accepting a bribe money of 3,000. And on the basis of the statement of the co-accused, eventually, my lord, the petitioner was also arrested. Thereafter, my lord, so-called notice was issued on 19/12/2023. That your lordship will find at page 30 of the writ petition. The mere perusal of the so-called notice will reveal that you have been arrested by the anti-corruption and vigilance official That is the, my lord, allegation. Man being arrested, that cannot be, my lord, an charge which amounts to misconduct, my lord.
Page
30 is the, my lord, show cause notice, 30. Even the statement of allegation also doesn't say anything. Only indicates that he has been arrested. The third paragraph from the top at page 30. Whereas as a part of the above transaction on 16/10/2023, one Faninder Das, son of so-and-so, was arrested soon after he accepted the bribe money of rupees 3,000 from Srimati Savitri Das Barua. As per your direction, accordingly, you were also arrested after getting sufficient evidence for demanding bribe and accepting it through middleman Sri so-and-so. This refers to ACB PS case number so-and-so. Now, my lord, will kindly turn to the next page, statement of allegation, second para, same thing. There is no specific charge. Only it reiterates that I was arrested on the basis of a statement of a co-accused. The veracity of the statement of the co-accused will be determined in a trial court, my lord. Now, my lord, thereafter I submitted my reply to this so-called notice. Departmental inquiry was initiated by appointing an inquiry officer. He conducted the inquiry in a perfunctory manner. Even the Faninder Das, who was actually arrested while accepting the money, he is not even a witness, my lord. So how demand and acceptance has been established, it's only based on presumption and assumption of the inquiry officer. The inquiry officer submitted its report to the disciplinary authority, and the disciplinary authority, Lordship will kindly come to page 37, annexure 6. Forwarded the inquiry report via the second so-called notice. Page 37, annexure 6. Now, this is very important because law in this regard is very clear. While furnishing the inquiry report, the disciplinary authority is supposed to take an open mind, and he is not, my lord, supposed to take a view which is against the petitioner, because while replying to the inquiry report, the delinquent officer should be given ample opportunity to persuade the disciplinary authority in his favor. Now, I humbly beg to read this, my lord, letter, which is very important. Page 37, annexure 6. May I read it, my lord?
Where's the inquiry report?
It's annexed with this, page 38, it starts the inquiry report. The inquiry report is always forwarded with this, my lord. The forwarding letter is called a second sort of notice, as your lordship already knows, my lord. Subject, second and final show cause notice. I have gone through the findings of the inquiry officer of DP number 1 of 2024, drawn up against you. Lordship will kindly mark this. I agree with the opinion of the inquiry officer that the charges framed against you have been proved in preponderance of probability. The second paragraph is even more important. I therefore found it a fit case for awarding major punishment for your gross indisciplined conduct and dereliction of duty. So the disciplinary authority has already made up his mind that I am guilty, my lord, and he proposes to impose major penalty upon me, even before I could reply to the inquiry report, my lord. So, my lord, my humble submission before this honorable court is that.
No, it indicates that the disciplinary authorities agree with the
Yes.
inquiry report, that's all.
But can he do so? That is the question. And my lord, the law in this regard is settled. I will place to judgments of this coordinate bench of this honorable court on this point, my lord. Thus will kindly permit me.
No, you complete the argument. Complete the argument.
Yes, madam.
You complete your argument.
Yes, your lordship. My first argument is that, my lord, if this lordship considers this procedural irregularity of predetermination of guilt, then it is a fit case where your lordship.
It's not question of predetermination.
No,
Inquiry has been conducted.
No, because the law says so. I am not saying, it is the decision of this
No,
honorable.
once the inquiry report is said, he has to decide. He has said,
No, he has to decide after receiving my reply.
it's okay.
If he decides at the time,
It shows that he agreed with the findings. I mean, the inquiry report.
yes, my lord.
That's all.
No, that he cannot do. That is my humble submission before this honorable court. This is where, my lord, the illegality or irregularity has crept in, my lord. And if your lordship accepts my submission, then this will be a fit case to remand back the matter to this stage, my lord. So that's why, my lord, with your lordship permission, I wanted to place the judgment instead
This is
of.
the only ground.
No, there are, my lord, irregularities in the inquiry report also, but if your lordship is satisfied, then your lordship will not go into the merit because on the procedure irregularity part, it has to be interfered with, my lord. Lordship will kindly peruse the judgment, it will make everything clear.
No, I'm not convinced.
Lordship will
You
kindly.
proceed.
Yes, Lordship will kindly peruse the judgment.
You
because
proceed, we'll see. Judgment we'll see later. What are the other?
It will, my lord, fortify my contention. That's why I'm trying to place the judgment.
Anyway, you proceed.
Yes, ma'am.
You proceed with the other grounds.
Yes.
Or you don't have other grounds?
No, I have other grounds, my lord. Now, my lord, apart from this, my lord, as your lordship knows, in a trap procedure, there are independent witness. My lord, independent witness, the trap procedure is, my lord, conducted in front of them. Here, the independent witness, my lord, didn't say accepting the illegal gratification by me, my lord, because I never accepted it. So, my lord, the demand and acceptance of illegal gratification, that is not established. The inquiry officer proceeds on assumption and presumption to hold that illegal gratification was, my lord, demanded and accepted by me, my lord. But that assumption and presumption cannot be a basis for making imposing major penalty of dismissal from service, my lord.
Demanding and accepting through middlemen.
No, that is through middlemen, my lord, that is their assumption. So it will be, my lord, established in a proper trial, whether he is a middleman or not, or whether he has demanded it from himself, my lord, or for
Are
some
you
other
saying
purpose.
that until the time it is convicted, you cannot be punished?
No, I am not saying that.
Cannot be imposed penalty?
My lord, a disciplinary proceeding can independently proceed.
Then?
But it has to have some material and the charges has to be
There's a
specific.
materials.
My lord, where is the charge?
Inquiry, there's so many.
No, inquiry has been conducted, but mayor conducting an inquiry, they have to bring.
Did you participate?
I have participated, my lord.
Then?
But mayor, my lord, if I have participated and if something is invalid, mayor participation will not.
What
make
is
it
invalid?
invalid.
What is invalid?
My lord, the charges has to be specific, as your lordship already knows, my lord.
What is the
Pardon, my lord.
What is the problem? What is the illegalities?
My lord, illegalities is there. My first contention is that, my lord, the charges are not been specific. No charge is there. Lordship will see the so-called, only it mentions that you were arrested. Somebody being arrested cannot be a, my lord, charge or a misconduct, my lord. Where is the charge? There is no specific charge, my lord. Lordship will kindly see the so-called notice. See the statement of allegation. No charge.
There must be charge.
Which will see peruse, lordship. I have annexed the so-called notice. There has to be a specific charge, as your lordship knows. So-called notice at page 30. Statement of allegation at page 31. It only refers that somebody was arrested, he's named you, and you were also arrested. That cannot be a charge, my lord. To bring home a charge of misconduct and resultantly dismissed from service, my lord. It has, the dismissal order has adverse civil consequences, my lord. Yes. Lordship will kindly turn to page 42. That is the part of the inquiry report. Page 42. May I read this, my lord? Para Roman 6. These are the statements of the independent witnesses before the inquiry officer. May I read it, my lord? Sri Akramul Mojid of Gorsal under Sipazar PS. On examination, the prosecution witness Akramul Mojid stated that on 16/10/2023, he was communicated over phone by the officials of DVNAC office asking him to come to the office. Accordingly, at the morning hours of the day, he came to DVNAC office and on reaching the office, met one Vinit Kachap. Both of them were asked to go to the conference hall of the said office and the TLO Rafiqul Hassan Chaudhary introduced them with the complainant of the case named Sabitri Das Borua. The demonstrator Bhaskajyoti Basumatari demonstrated by coating the chemical phenylephrine powder on the currency notes. Accordingly, the demonstrator coated the powdery substance on the currency notes given by the complainant Sabitri Das Borua and showed them a serial numbers of the currency note. After the demonstrator washed his hand with the water and on washing the water got pink color. The said water, 250 grams, were preserved by the inspector Bhaiti Ahmed in the bottle and sealed it. The powder coated currency notes were kept in the bag of the complainant. Now this is important, my lord. After doing so, he along with other members of the
Where's the translated copy? I mean, typed copy.
My lord, type copy is not given probably, my lord. Type copy has not been given. I can provide if your lordship wants, my lord.
It's not legible. The powder coated color notes were kept in the bag of this container.
After doing so, he along with other members of the trap team and with Abhijit Kashyap left DVSC office to Boko PS at 11:30 a.m. of the day. They arrived near Boko PS and there at about 12:15 p.m. the next page of the day. The TLO Rafiqul Hassan Chaudhary informed over phone that involved person has been appeared.
It's not the continuation.
I'm sorry, I apologize, my lord. Then lordship will kindly permit me to give a type copy of this, my lord. I did not. I thought it was the.
Anyway, what do you want to say from here?
It is specific from their statement also. The TLO Rafiqul Hassan informed over phone that the involved person has been apprehended. The independent witnesses who are supposed to witness the my lord trap, they have been informed over phone that so and so has been arrested. So, my lord, where from the inquiry officer comes to the, where is the evidence?
What? Of what?
Regarding my acceptance, demand and acceptance of bribe. That is the only issue.
Left to read entire this thing.
Then, my lord, lordship will again. Lordship will come to page 46. Para 3. The charged person, ASI Mukutali, that is the petitioner, was caught red-handed in a hotel. Where from he is giving this finding, my lord? I have never been caught red-handed. It is on the basis of a statement of a co-accused, my lord. He was caught red-handed.
You'll have to read whole evidence, not the only one evidence.
No, my lord, what I am trying to impress upon your lordship is, the inquiry officer says I was caught red-handed. Then, my lord, at para 6, he says, my lord, it is established that the hotel owner, Faninder Das, received the bribe money of so-and-so from Sabitri Das as per instruction of the petitioner. Clear contradiction, my lord. On one hand, he says, I was caught red-handed. At the same breath, he says, no, the other person was caught red-handed. Not.
Who has said so?
Pardon, my lord.
Who has said?
The inquiry officer. Para 3 and para 6 at page 46, my lord.
Para 6 is his finding?
Yes.
Huh?
Yes, para 6 at page 46. At the same rate, he can blow hot and cold, my lord. Para 6 at page 46. Para 3, he says, I was caught red-handed. Then para 6, he says, Fernando
Para 6 is very not clear. It's not complete also.
Page 46, my lord. Page 46.
Page 42.
Page 46.
Then the base is on page 46, 42. This is the finding. Page 45 also. Findings of the inquiry has been, in fact, which has to be focused in favor of Alice has been presented below. What is FRACB substantiate so and so? These are all blank.
Lordship will then permit me, I apologize, Lordship. Lordship will permit me to give a type copy, my lord.
Or any other ground? Any other ground?
My lord, this procedure irregularity part, Lordship will kindly peruse the judgment. One para I will only rely, only one para. My lord, this is reported in 2004 to GLT, page 259. For facts, Lordship can refer to para 5. Same disciplinary proceeding was, may I read para 5, my lord? Then, my lord, Lordship will kindly turn to the findings of this honorable court. Para 13, my lord. Lordship, permit me to read this para 13. This is very important, my lord. May I read it, my lord? Para 13, 1-3, my lord. May I read it, my lord? This leads us to the last issue, which is whether the disciplinary authority acted with her predetermined mind and denied the opportunity to the petitioner to have his say in the respect of the inquiry report, so as to persuade the disciplinary authority to take a different view from the one taken by the inquiry officer, resulting in miscarriage of justice. On perusal of the letter dated 3/3/98, by which the inquiry report was forwarded to the petitioner, with the proposal of imposing the penalty of removal after agreeing with the findings of the inquiry officer, there is no iota of doubt that the disciplinary authority first made up his mind upon agreement with the findings of the inquiry officer to impose the penalty of removal from service, and then asked the petitioner to furnish his reply to the action proposed and not to submit any representation against the inquiry report. Thus, it is a case of empty formality in as much as the disciplinary authority, even before furnishing the copy of the inquiry report, asking the petitioner to submit his reply, and then upon consideration of the inquiry report and the representation to arrive at a finding relating to the penalty, came to the provisional finding in agreement with the findings recorded by the inquiry officer to remove the petitioner from service, and the petitioner was asked to submit his reply not against the inquiry report but against the penalty proposed against him. Thus, the disciplinary authority acted with a predetermined mind towards imposition of the penalty of removal against the petitioner, even before he could make his representation persuading the disciplinary authority not to accept the findings recorded by the inquiry officer. There is a purpose behind affording the opportunity of making representation against the inquiry report and cannot be in empty formality But in the instant case, the disciplinary authority first decided, maybe provisionally, to impose penalty of removal on the petitioner upon an agreement with the findings of the inquiry officer, and then ask the petitioner to submit his reply against the action proposed and not against the inquiry report. Thus, the link between the final decision and the representation against the inquiry report is missing in the instant case. So, my lord, thereby the impugned penalty order was interfered with, my lord. And this has been, my lord, the consistent view of this honorable court. In another judgment, I can place, my lord, this was relied on where same, my lord, under the similar facts, the impugned penalty was interfered with and the matter was remanded back from this stage, my lord. May I place the judgment, my lord? Dada. Under similar facts, my lord. Recent judgment, so it is not yet to be reported, my lord, by a coordinate bench. Lordship, for facts, Lordship can refer to para 13 and 14. And findings such from, my lord, para 15. May I read para 15, my lord? Para 13, 14, Lordship may refer for facts, and 15, my lord, the observation of this honorable court. Para 15, I am reading, my lord. It is settled law that after completion of the inquiry, it is mandatory to furnish a copy of the inquiry report to the delinquent in order to give the delinquent an opportunity to persuade the disciplinary authority not to accept the said report. However, if at this stage the disciplinary authority indicates in the said so-called notice that the inquiry report submitted by the inquiry officer is already agreed and concurred by the disciplinary authority, it defies the conscience of this court as regards the open mind of the disciplinary authority in pursuing the matter. Thereafter, this, my lord, Babulal Das, right, just now I have read, my lord, at para 17 it has been referred and quoted, my lord. Thereafter, Lordship will kindly come to para 19, my lord. Reading the above, what emerges is that it is imperative for the disciplinary authority to act with open mind and a predetermined mind at the stage of issuance of the second so-called notice to the delinquent after completion of the inquiry, whereby he is given an opportunity to persuade the disciplinary authority not to accept the inquiry report. Thus, if the disciplinary authority at the stage of second so-called notice agrees the findings of the inquiry report, the issuance of such notice becomes an empty formality, and the same will be totally prejudicial to the interest of the delinquent and against the principles of fair play and natural justice. Apparent that in the case in hand, the respondents, by concurring with the finding of the inquiry officer, have not proceeded with an open mind, and therefore the impugned penalty is vitiated. Para 22, my lord. In view of the above, impugned order of removal from service dated so-and-so is illegal and is hereby set aside. Next page, my lord, para 23. Resultantly, the petitioner is directed to be reinstated in service. However, taking into consideration the nature of charges, the respondent authorities, if so advised, may proceed from the stage of issuing the second so-called notice against the report of inquiry officer and thereafter to take a decision strictly in accordance with law. In that event, interest of justice would require that the disciplinary authority should be played by any other person competent to discharge the said role other than the officer who was the disciplinary authority at the relevant point of time. So, my lord, I am relying on these findings of the coordinate bench to impress upon your lordship. If your lordship reads the second so-called notice, that is the forwarding letter of the inquiry report, once again, my lord, it will make the position clear again, my lord. At page 37. At page 37, annexure 6 of my writ petition, my lord. May I read it, my lord? Subject second and final show cause notice. I have gone through the findings of the inquiry officer of DP number so-and-so drawn up against you. I agree with the opinion of the inquiry officer with the charges framed against you have been proved in preponderance of probability. I therefore found it a fit case for awarding major punishment for your gross indisciplined conduct and dereliction of duty. Copy of the findings submitted by inquiry officer is enclosed. You are hereby asked to submit your written explanation within 7 days, the findings of the DP. At page 37, my lord. So apparently there is, my lord, predetermination of guilt, which cannot be sustained under law. Because an opportunity has to be given to me or the delinquent officer to persuade the disciplinary authority not to accept the inquiry findings of the inquiry report. My lord, this was, my lord, violated, and the disciplinary authority made up its mind to impose major penalty. So in my humble submission, and as per the consistent view of this honorable court, it is a fit case wherein your lordship will interfere with the impugned penalty order, remand the matter back to from this stage of serving the inquiry report, so that the disciplinary authority keeps an open mind, considers my representation, and thereafter comes to a conclusion, my lord. And the inquiry disciplinary authority has to be some other person because this person has already taken the view, my lord. That is my humble submission before this honorable report.
So basically,
Lordship.
Essentially you are on that, the disciplinary authority
Procedural
before
irregularity.
issuing a,
Yes. And expressing his mind. It is not permissible under the law.
had a predetermined mind.
Yes.
Hmm.
And if I succeed on this, I need not go into the merits of the case because it will be a fit case for remand back from this stage. In both the cases that I have placed, the remanded back from this stage. And no appeal has been filed against these two orders. They have attained finality, my lord.
Your appeal has also been dismissed.
Pardon? No.
Statutory appeal has been dismissed.
I filed a departmental appeal, but they did not, my lord. The appeal your lordship will find that page. They have upheld the dismissal order, rejected my appeal, my lord. If that is order, lordship will find that page 65, the appellate order. They just simply mechanically they have upheld.
Yes.
Yes, my lordship. First of all, page 30, my lord, petitioner's allegation is that there is no specific charge. I am giving that first show cause notice. It is a case, my lord, a tape case. So, my lordship, kindly page 30, paragraph 3. whereas part of the above transaction means he received rupees so and so of Sabitri Bora through middleman. Whereas as part of the above transaction on 16 October 2023, one Sri Fonidhar Das, led so and so was arrested soon after he accepted the bribe money 300 from Sabitri Bora as per your direction. As per your direction, he received the money. Accordingly, you were also arrested after getting sufficient evidence for demanding bribe and accepting it through middleman, so and so, under section so and so. This action amounts to violation of civil service rules 1965 oblique other statutory provision, misconduct in the performance of official duties as well as abuse of the official position. It is clear.
Where is the memorandum of charges?
Yes, memorandum of charges.
Where is the memorandum of charges?
Memorandum of charges, Lordship, statement of allegation is there.
Ah,
These are the first show cause notice and statement of allegation is there.
statement of allegation. Where is the memorandum charges? Where is the charge?
Charges, this is just a charge, where is the part of above.
Where is the memo of charges?
Memo, extra memo is not on necessary, my lord. Records with me, my lord. The extra memo charge is not necessary because first show cause notice, it has been charged. His charge has been given here. Charge him. If the disciplinary authority decide to appoint an inquiry officer into the charges, you will be allowed to present your case. Because charges means that amount was received by middleman. That was the charges. And list of documents and list of witnesses were given. Accordingly, he replied it. Thereafter, inquiry was held as per procedure. And as per inquiry, the second, after completion of the inquiry, recording statements of the witnesses and others, my lord, the second so cause was issued. That is the procedure. Second so cause issued with a inquiry report. That is the procedure. There is no violation of any provisions, my lord, in the law. And accordingly, he replied to the second position, my lord. Second so cause notice, he replied it. And Lordship Kallis, page 43.
Read this, page 37, second so cause notice.
Yes. 37, second so cause. I have gone through the findings of the inquiry report of DP number so and so drawn up against you. I agree with the opinion of the inquiry officer that the charges framed against you have been proved in preponderance of probability. But it's not a criminal case to prove legally, technically, it's and everything. The preponderance of probability, I therefore find it fit case for awarding major punishment for your gross indiscipline conduct and dereliction of duty. Copy of the findings submitted by inquiry officers and closed herewith. You are asked to submit your written statement and explanation in any within 7 days in response to the findings of a DP to undersign. The in default discipline authority will take. My lord, this purpose of the issuing second so cause notice is to give him an opportunity to reply.
Give the opportunity or to give the on penalty.
No, my lord.
Because you have already decided, you have already agreed.
No, my lord, he is not imposing major penalty. He says that this inquiry report I have seen and it demands and it requires major punishment. That is, he says. He is not saying I am imposing penalty. After receiving of his reply on the second so cause notice, then my lord impose penalty. The Lordship Kallis is trap case. Trap case, my lord, what happened, Lordship knows it. Let's page 43. Page 43, my lord. The TLO had already informed over phone that the involved person has been apprehended. Then he, along with the members of the trap, took the apprehended person to Boku PS and came to know that the said person hand over case to the hotel owner, who after receiving the case fled away from the spot. A few minutes later, the said absconded person was apprehended and brought to Boku PS. The body of the said person was charged and could recover and 3,000 rupees from his possession. In the later course, he came to know that the names of the person Mukutali and Phoninder Das, the hands of the both persons were washed, and on washing, the water content became pink color. The water content was seized by the investigation. So both the persons were washed, which is sodium chlorate, that is a chemical, was given to the money and to the money, and whoever touch the money, my lord, it becomes pink. That is the place. It is not a preponderance, but it is also a fact, but it is true that he accept the bribe. It is proved. The inquiry also proved. And then lordship kindly see another thing, my lord, page 51. Page 51, my lord, order. 1, 2, 3, 4, paragraph 4, my lord. On examination of PW Sri Rafiqul Hussain Chaudhary, TLO.
What is TLO?
TLO means trap, TLO, my lord, trap
Trap
lying
laying
officer.
Trap laying officer, my lord.
There's a trap lying officer, he was.
Trap link officer.
Yes.
Laying.
Trap laying.
Who contact? Trap laying, huh?
Laying officer. Assam stated a such person, Mukut Ali, came into contact with the Sabiti Das over phone, by which he demanded 6,000 rupees as bribe from the Sabiti Das Borua for producing the case diary in the case of before the Honorable Court. On our examination, Sri Joyanto Kumar Das, Inspector of Police, BVNSC, stated that the fact of demanding bribe was found true as substantiated by the audio clip which was recorded by Srimati Sabiti Borua Das Purva. The audio clip was verified and found genuine as per a statement of PWD. On examination, PWD Sri Akramul Majid, Pion, Assam Simonto so-and-so, on 16/10/2023, he, along with the other members of the trap team and witnesses Abhijit Kaisov Lab, DV, Director of Vigilance and Anti-Corruption, DV and SC, Office Boku PS. At about 11:30 am of the day, they arrive here near the Boku police station about 12:15 p.m. The TLO Rafiqul Hussain Chaudhary informed her that the fraud data involved person has been apprehended. Then he, along with the members of the trap team, took the apprehended person, Mukut Ali, who handed over the case to the hotel owner of Sri Ponidor Das, who, after receiving cash, fled away from the spot. The said second person was also, the absconded person was also apprehended few minutes later and brought to the Boku PS. The body of the said person was charged. An entire amount of 3,000 was recovered from his possession. The hands of both the persons who were washed, and on washing the water become bricks. That is true, and there no further evidence is required in the trap lying cases, my lord. So my humble submission, your lordship, there is no violation of any procedure prescribed in the law with the department proceeding. And in my humble submission, I have two cases, my lord. I am giving it, my lord. I don't have copy, my lord. I am giving lordship. Two cases, and this is this. Just I have written here, my lord, lordship, kindly go through it, my lord. The first case is 2023 SSC 423. That is the, my lord, State of Karnataka versus N. Gangaraj, decided in 2020. Paragraph, lordship, kindly see paragraph 7. We find that interference of the order of punishment by the tribunal as affirmed by the High Court suffered error. The power of judicial review to the decision-making process. The power of judicial review conferred on High Court and the tribunal is not that of an appellate authority. That was prescribed, and para 8 in the state quoted the Andhra Pradesh case, in para 7 of the Andhra Pradesh case. The High Court under Article 226 of the Constitution is not court of appeal over a decision of the authorities holding a DP against a public servant. It concerns to determine whether the inquiry is held by an authority competent in that behalf, and according to the procedure prescribed in that behalf, whether rules of national justice are not violated. Where the authority accepted evidence of inquiry which supported the conclusions of the authority.
This is para
7 of paragraph 7. This Andhra Pradesh case, para 8. I am reading the para 8. Para 8, there is a para 7, Lordship Kalisi case. The High Court under Article so and so. Whether the national justice is violated or not, it is not a function of the High Court under Article 226 to review the evidence and to arrive at the independent findings on evidence. I am make it there. And next, Lordship Kalisi, paragraph 9. They discuss about the BC Sotumati case. in para 13, para 9 within that 13. This automatic case. The disciplinary authority is sole judge of the facts where appeal is presented. So, disciplinary authority is a sole judge of the facts where appeal is presented. The appellate authority has coextensive power to reappreciate the evidence or the nature of punishment in a disciplinary inquiry, and the stick proof legal evidence and findings on that evidence are not relevant. This is a preponderance of probability of charges, my lord, in the DP. As Supreme Court says, in disciplinary inquiry, the stick proof of legal evidence and findings on that evidence are not relevant. Adequacy of the evidence or reliability of the evidence cannot be permitted to be canvassed before the High Court. So, there is evidence is adequate and it is not reliable. You cannot canvass it. Well, the facts, wherever accepted by the Department of Authority, is a sole judge of having this coming to the conclusions on the findings of the inquiry officer. And next, Lordship, kindly see discrepancies. And para 11, para 13, Lordship, kindly. We do not, I am reading, but Lordship will find it all the thing. I do not find that even on touchstone of the facts, tribunal or the High Court to interpret with the findings.
You are reading from here.
I am reading from paragraph 13 of the case, paragraph 13. Paragraph 13, I am, I don't have that other copies paper, problem is there, I am reading from my notes. 13 paragraph, we do not find that even on touchstone of the facts, tribunal or the High Court to interpret with the findings recorded by the disciplinary authority. It is not the case of no evidence, and the findings are perverse. The findings that interfered by the High Court and tribunal on the basis of the discrepancies of evidence by department. The discrepancies in the evidence will not make it case of no evidence. So it is not a case of no evidence, my lord. There is evidence there, my lord. Trap-like procedure is there. Witnesses are there. The discrepancy may be some, maybe, but it is does not mean that the case is no evidence. And paragraph 14, the disciplinary authority agreed with the findings of the inquiry officer and imposed punishment. Appeal also rejected by the government. Once the evidence has been accepted by the departmental authority in exercise of judicial review, tribunal or the High Court could not interfere with the findings of the facts recorded by the reappreciating evidence as if the court is the appellate authority. Therefore, the High Court and tribunal has order is set aside. And next case, Lordship, two cases there, my lord. One case is the 64-year Supreme Court, H.C. Goel. Second case, Lordship, my lord, I am reading only two paragraphs, my lord, paragraph 11. Article 311 consists of two sub-articles and their effect is no longer doubt. No longer doubt. It is well settled that public servant who is entitled to the protection of Article 311 must get two opportunities to defend himself. He must have clear notice of charges before the DP and after gets such notice and is given opportunity to offer his explanation. The inquiry is to be conducted according to rules and natural justice. And at the end of the inquiry officer appreciates the evidence, records his conclusion and submits his report to the government concerned. This is the first stage of inquiry, and this stage validly begins only after charge, only served to the delinquent officers. So where is wrong, my lord? He has served the first show-cause notice. He given opportunity to explain it. He accordingly submit reply.
Oh,
After the
that he
inquiry,
is not disputing. What he
yes,
is disputing.
I am reading, my lord. Thereafter, I will offer my paragraph 20. I'm shortcutting, my lord. Second opposite to the public servant is entitled can be effective only if the competent authority offers inquiry is over and after applying its mind to the gravity and otherwise the charges proved against the government servant, tentatively propose to inflict one of the three punishment and communicate the same to the government servant. Tentatively, my lord, propose to inflict. So he says that why major punishment should not be inflicted, not deviate them a lot any irregularities of the departmental proceeding. Opportunity is that if the Chief Justice refers to the charges proved against the government servant, it is not intended to be suggested that the findings made by the inquiry officer in their behalf are final. The inquiry report along with the evidence recorded constitute the material. The inquiry report along with the evidence recorded constitute the material on which the government has ultimately to act. That is the only purpose of the inquiry held by the competent authority and report which has makes a result of the said inquiry. Therefore, we have no hesitation to holding that the High Court and the tribunal was error in coming to the conclusion that the appellant was not justified in differing from the finding recorded by inquiry officer. And last is paragraph 24. It is important paragraph, my lord. In exercise under the Article 226 of the Constitution on such a plea that the High Court cannot consider the question about the sufficiency and adequacy of the evidence in support of the particular conclusion. This is the matter which within the competence of the authority which dealt with the person. Therefore, that is my harmful submission. The petitioner says there is discrepancy. The discrepancy does not confer these findings of the illegal and perverse. So my humble submission will say there is no any iota of evidence, my lord, avoiding any procedure, and they did not follow the procedure at the time of the public proceeding. Ample opportunity was given to the petitioner to defend his cases, and there is no wrong at all. And accordingly, he accepted the opportunities and replied so and so. And witnesses are examined. All he cross-examined also, my lord. There is no question of that he is not given. He cross-examined so witnesses. He only says that bribe money 3,000 was not recovered from me. But my lord, the departmental proceeding, it is not a criminal case, my lord. The departmental proceeding preponderance of charges is proved because this amount was handed over by the complainant to the hotel owner at the instruction of the petitioner. That means he accept the money indirectly from the third person. So from the third person in the middle person. Through the middle person, he accepted the money. That is, it is proved. That's why my humble submission of lordship. It is not a case to remand back or otherwise to ballot set aside the ballot disciplinary authority and the punishment order inflict upon the petition. That's why my lord. And another case is also, my lord, I am citing here. Deputy Inspector.
No, as per the second sock, what he said, he has determined, you have predetermined.
Not determination, but he only says, second so goes notice, that why major punishment. Mentioned that punishment may be minor or major, but after his reply, they impose penalty. It does not mean the malady. He mentioned only that why major punishment should not be inflicted upon you. You are hereby given opportunity to explain. It does not mean impose penalty. Penalty imposed after his reply. And under case, my lord, I am citing one side judgment detail. Deputy Inspector General of Police, my lord. It was on paragraph 23.
On what? On what point?
I am giving it, my lord. It is settled law that the strict burden of proof required to establish guilt in a criminal court is not required in a disciplinary proceeding. And preponderance of probability is sufficient.
That is all settled.
Yes, for that, my lord. I mean, and paragraph 25, in view of the above mentioned circumstances, we have the view that High Court was not justified in setting aside the punishment imposed in a departmental proceeding as against the respondent. It is limited jurisdiction under Article 223. That for this purpose only, my lord, I am giving this case.
No,
there are two cases, my lord.
There is settled already.
Yes.
These are settled laws.
They settled law, my lord. That's why, my lord, this is my humble submission, my lordship. There is no any irregularity in, my lord, drawing departmental proceeding and subsequently on the material collected in the evidence during the procedure, departmental proceeding, and evidence recorded, statement recorded of the witnesses, my lord, they have come to the conclusion that major punishment is required to be inflicted. Accordingly, they have imposed it, and he also filed appeal. Appeal also, my lord, that has been rejected. So in this case, my lord, my humble submission for lordship, there is no any
You have rejected, therefore he is before this court only.
That's why, my lord, my submission before lordship, my lord, this is not a fit case to remand or otherwise set aside the inquiry.
You have the records.
Records. I have records, my lord, so vernacular families, my lordship.
It's a problem. Inquiry report is also vernacular.
No. Statements are vernacular, my lord. Other side here, annex here, statement of evidence all her.
No, he has annexed the inquiry report.
There's the English. It is all okay. Only statements of witnesses.
It's there.
No, inquiry report is there, my lord. Is it English? Is it annexed it, my lord?
No, no, it's not incomplete.
No.
Half
Oh,
of the
oh, okay.
pages,
Yes, yes, yes. Oh,
some
okay.
pages are
Yes, 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 yes.
not legible.
Yes, yes. Like my assembly. Yes, my lord. I will give you that. Like my assembly.
Like my letter.
Yes, yes, legible copy. Okay, that's clear. Yeah. Like my.
Original,
Original.
it's original.
Original.
Just plug it.
Like my. It.
See, only issue is, according to you, whether the page 37, second subordinates amounts to predetermined
Yes.
of mind.
Lordship,
That's all.
yes, Lordship, I have,
He has relied two cases. Yes, Mr. Chutia.
My lord.
He has relied two cases where this court, coordinate bench of this court has held that, I mean, just second so-called notice, if it's the
Predetermined.
language, almost the language is same. Languages are same.
That's why, my lord, I am
So,
citing two cases, my lord.
no, these two other cases, this court has, the coordinate bench has relied.
Lordship, the judgment in WPC 5574, the unreported case, my lord. That will kindly take that. Just the short reply to my learned senior, my lord. WPC 5574 of 2018. That will kindly come to para 13 of the judgment at page 5. The second so-called notice issued in that case has been quoted. In my case, it is worse. Here only is the, may I just read, my lord. Since I concur with the above findings of the inquiry officer that charges number 1 to 4 are proved, you are advised to submit your, here only.
You show the judgment to him.
Yes. Here only the disciplinary authority used the word concur. Then also this honorable court came to the conclusion, no, the disciplinary authority did not proceed with an open mind. So it was remanded back. In my case, page 37, it is even worse. He concurs, then he proposes to impose major penalty, my lord.
No, no, that can be done. Concur to, it can be done.
It cannot be. He gets to keep an open mind till I file my reply against the inquiry report.
It doesn't, concur doesn't mean that you will.
But this honorable court has interfered with me. That is the judicial finding, my lord.
Yeah, my lord, quoted the paragraph. That's it. Here only lots of penalty. This leads us to the last issue, whether the disciplinary authority acted with a predetermined mind and denied opportunity to the petitioner to have its say. We are not denying. Or not denying, but we are given an opportunity.
To have say in my inquiry report.
Every case.
Okay, we'll see.
Defined.
Only this issue will decide.
Yes, ma'am.
Others too, there's nothing wrong.
No,
May I not submit memorandum of charges?
Charges are not there, my lord. It is apparent. Lordship knows, my lord.
Charges are there. Memorandum of charges has not been formally given. That's all.
Yes.
Charges has to be specific. A person being arrested, that cannot be a charge to prove misconduct, my lord.
What's that? Any judgment on that?
Lordship, I can give. I'll just give me some time, my lord. I'll give to the bench master.
Charge is given, my lord.
Charge has to be specific, my lord.
Specific charge. Because
you were arrested. That is a statement.
Pastor was arrested.
Charge, my lord.
Why arrested? You
arrested
money.
That's why
that we mentioned in the matter. This is charge.
But will give me 5 minutes. I will give it to the bench master. Specific. The judgment on a point that the charges has to be specific, I will hand it over to the
No, specific is there, but what is the memorandum of charges formally to be given? That's
my humble submission is the
okay, heard Mr. J. Patwari, learned counsel for the petitioner, and also heard Mr. T.C. Chutia, learned state counsel for the all the respondents. Hearing concluded, judgment reserved.
I'm deeply obliged, Your Lordship, for a patient hearing.
I have been assisted by my lord D. Libby.
Assisted.
Lordship has been very kind.
Huh?
Lordship has been very kind to hear me with all my shortcomings.
We-
Lordship.
Okay.